afternoon and welcome to our CBASS webinar called ESG and Climate Litigation, the next goldmine for your legal practice. My name is Li Jin Chin, and I am the chairperson of Circular Business Association. And I'm very honored to be able to have with me as a guest speaker, Sir Louis Chung, who's Senior Managing Partner of ACMF International Private Fundraising, to actually do this webinar together and discuss this very important topic about climate litigation and ESG, not only in terms of the impact that it can create, but also in terms of its business opportunities that will emerge. So just a little bit background about myself. I actually have a background in environmental sciences and then in environmental economics as my master's degree. And I'm also one of the fellow of the Smith MacArthur Fellowship on Circular Economy, and really have been involved with a research company for a lot of government agencies. So we were a private company, but we were doing a lot of background studies, background research for governments before they change programs and policies in order to provide them with the evidence that would support these changes. So I had the opportunity to actually participate as being one of the team members writing the final final review of the Millennium Development Goals for Malaysia back in 2015, and also was part of the team that wrote the voluntary national review as well as the first phase Sustainable Development Goals roadmap for Malaysia in 2016. Apart from that, I've had the opportunity to also be part of a number of different studies that have included waste management, recycling, the bottom 40% development action plans, the indigenous people action plans, and also was one of the non-legal experts that was invited by the Bar Council of Malaysia to curate a 5-part series on enviro rights, the Bar Chat series, which is available on a podcast, to look into the emergence of ESG related legal practices. Yeah, that was something that's available that you can search for. It's on the Bar Council YouTube channel, I think, or podcast channel. So with that, I hope that gives a bit of background about myself. Thank you very much for joining us in this webinar today. I'll start off with my presentation on the rise of ESG and climate legal action and the opportunity it creates. And then we'll follow by Louis's presentation, which will be on, is ESG a $1 trillion industry? How companies can benefit from mandatory ESG reporting. And then we will open the floor to question and answer, so as a slight discussion. So if during our presentations you do have any questions, please feel free to drop it inside the chat, writing the word question, so that it's easier for us to pick up on your question and try and address it during our Q&A session. All right, so let's get cracking. Now, why is this topic even emerging of climate and ESG litigation being a next goldmine for the legal practice? Let's just look at some of these trends that actually emerged in the last 2 years. We've seen an explosion of cases that's emerged in this realm. Now, this diagram actually shows the number of cases to date in different countries globally where we've seen climate litigation actually emerge. And you can see that at this point, there's already more than 55 countries already having cases brought to courts. Of course, there's a majority of it at the moment being filed in the United States, but there have also been new countries joining this in the last 2 years. And at the current point, this study was actually done by the London School of Economics together with the Columbia Law School and the Climate Change Lawyers of the World and Grantham Research Institute. And they were looking at global trends in climate change litigation for a number of years already. Since the 1960s, they've detected legal cases in that sense. And currently they have 2,666 climate litigation cases, of which 70% had only appeared since 2015, which is the year that the Paris Agreement on Climate Change was adopted. It was also the year where the Millennium Development Goals expired and the new Sustainable Development Goals was adopted. Now, there were a number of really interesting cases that just emerged in 2024 alone, which included 50 new cases that were filed. And the European Courts of Human Rights actually recognized that there was government failure to act on climate change based on the human rights case called Climate Snurian and against the Switzerland government. There was also a landmark ruling in the US, which was described as the first big win for the US youth-led climate litigation movement. And there was also 97 new cases that were filed in 2023 talking about needing to include climate into decision-making considerations. So for example, there were licensing licensing-related cases against a stakeholder that rose the case against the energy ministry of a government. And such cases have actually resulted in delay, abandonment, or postponement and resubmission of a lot of documents for those companies and national authorities as well. So greenwashing by the Forbes magazine has actually been something that's been picked up as being the next goldmine for litigators. And it's not only happening in so-called, you would imagine European Union or the United States or UK and Australia, but it's actually growing across the world as well. In fact, people have actually found that when companies are actually sued for ESG violations or climate violations, the chances of them winning is actually very low. 70% of the time, climate washing cases are actually lost by those companies. To give you some examples, there's a Volkswagen who was actually fined 34 billion US dollars over their ESG matter for reporting lower pollutants than actually was. So they actually had fibbed their software system to actually detect lower emissions from their cars than what they were reporting. We saw a similar situation with Toyota being fined 180 million over their sustainability claims. We had DWS, which is an investment firm, being fined 25 million, again being misstating the ESG statements. Mercer, again, was another investment firm that was fined 7.5 million US dollars over inaccurate ESG data. Wisdom Tree being fined 4 million US dollars. This is an asset management company. And this was in 2024 alone in Australia, actually, that they got fined this amount. And not only, big sort of motor companies or even these investment firms. We've also seen similar trends actually emerge with fashion brands as well, like Shein, Lululemon, ASOS, being investigated by the regulatory bodies and then publicly needing to apologize and remove all their sort of greenwashed or green stated labels on their clothing because they couldn't substantiate the claims that they had made that, this particular clothing was of climate friendly or green or ESG eco-friendly. And they had to actually make a public apology. The regulator wrote an open letter to name these brands as well. And the result that was in settlement. They didn't get to court yet, but they actually settled and paid for all the costs that was needed to actually deal with this correction of their misaction. Now, one may think you would need a specific law to deal with greenwashing or like climate washing. But that's not actually the case, right? I mean, of course, we do see in the European Union, their parliament has actually gone ahead with discussing this directive called the Green Claims Directive to crack down on greenwashing. But we've actually seen similar crackdowns happen in other countries as well, and they actually didn't even require the usage of a climate law or a environmental law per se. We've seen some examples coming in from advertising law, whereby, for example, China actually has taken a strong stance on that. And we've seen it in the UK as well against banks like HSBC, against Lloyds Bank. For example, this one, the Advertising Standards Authority, actually held a claim against the Lloyds Bank banking group, as well as HSBC for advertisements of which they could not substantiate, or they were diverting and distracting consumers away from their major investments, which is still very much involved in oil and gas and fossil fuels, etc. They were distracting them by saying they were doing things like tree planting or helping the clients to hit climate targets, but that was a very small percentage in their operations compared to what they were funding in terms of carbon intensive industries. We've also seen some examples coming in from market authorities. For example, we saw in UK, they actually were dealing with, apart from ASOS, there was Boohoo, Georgia Asda, whereby there was no formal enforcement powers, but they were able to use their market authority and consumer protection laws to actually go after these major companies. We saw the same thing happen in France and Italy, as well as in China as well, over trademark laws, whereby they've actually specified that these particular trademarks are not allowed to be registered in China. So if there are sort of corporate clients that are looking into expanding into China and they have these type of trademarks, they would need to actually change their trademark and logo in order to enter that realm. These were actually raised on the grounds that it was deceptive in nature and it might lead to misleading public regards over the characteristic, quality, or content of the good and services. So until a company can actually substantiate that they are green with the data, they would not be able to use these trademark laws. So it's quite interesting that even though there are many countries that have not yet adopted a formal sort of directive over green claims, that they're using these existing laws that's well established and then just adding guidelines to it in order to take action against these companies. And in 2020, in the 2020s, I would say that something very interesting also happened because these cases can actually get quite personal. Now, in 2022, for example, directors and executives from a utilities company in California actually was sued for negligence over the company's safety measures to prevent and deal with the destructive wildfires that happened. And it was a lawsuit filed by a trust established by the wildfire victims. And in the end, they went for a settlement of 117 million US dollars. Another example, in 2023, December, a Polish power generation company, Enea, actually sued their former directors and insurers because the company actually had suffered damages as a result of their directors signing off a power plant project, despite shareholders already, minor shareholders already raising concerns over that project because of increasing prices of carbon tax, the competition from cheaper renewables, as well as new EU regulations. So these former directors, which are individual people, right? They weren't going after the company itself, were suing them, actually had to settle for 157 million US dollars. This is a very novel type of claim because the company had already lost their own legal suit and suffered 650 million Polish dollars, which is equivalent to 152 million euros. And they therefore, because the company suffered that loss and had to cancel the project that was built halfway, they actually went after their former directors and managed to get a settlement of 157 million. And it's not just greenwashing that's been happening, right? There's actually been a spew of regulatory action that's been exploding in the last 2 years. So one of it that is definitely something high on everybody's radar is these new directives around corporate sustainability reporting, or what they would call mandatory sustainability disclosures. EU has already started implementing their CSRD with their guidelines that is founded on the same methodology as the global baseline methodology, the ISSB standards. China has also moved in that direction. They've already introduced their draft reporting guidelines, and we're likely to, they've finished the consultations on this. Again, it's based on the same ISSB standards. We've seen the same thing happen in Singapore, whereby it's not just public listed companies, but also large non-listed companies above a certain revenue size that need to do disclosures mandatorily. I've seen the same happen in Malaysia. And as you can see, the timelines that have been put in place by these regulators are actually really, really short, right? In Malaysia's example, the earliest that you have to start reporting is actually this year. So next year, the report needs to come out over all the data that needs to be collected this year. And what's interesting is that apart from these methodologies needing to cover the own company, they've actually specified that it needs to cover the value chain network as well, which means that all the suppliers and vendors of these companies that need to do mandatory reporting will also need to be covered according to the methodologies guidelines. So there is a number of countries that have, of course, over the recent months have continued to release their reporting standards, moving into mandatory reporting, not just Japan, but China, South Korea, even Switzerland, Costa Rica, the United Kingdom, Canada, Singapore, Australia, Philippines, etc., have already moved in this direction. Apart from that, we've also seen other types of regulatory action as well, which includes things like border mechanisms, whereby goods and services that are moved in between different borders might be subject to taxes like carbon tax. And in order to prepare for that carbon taxation, they would need to have disclosures to actually say how much of these greenhouse gas emissions is trapped within the product itself, and therefore the importers of those products, importers in the EU importing those products would need to pay an additional tax. And that would actually follow fluctuating carbon pricing that's happening in the EU market. So for suppliers and vendors that are supplying overseas to the EU market, this is something that would be high on their radar, because not only do they have to disclose the information, but they might also need to be ready to deal with the financial implications as well. Now, maybe you're starting to ask, why suddenly, just in these like short 2 to 3 years, we've seen like this huge explosion of action from the regulatory and legal front? Now, the elephant in the room is, of course, the physical environment that all of us live in. And our climate system is essentially like the operating system, like our phone, right? If your iOS or Android system breaks down, it doesn't matter how good the apps are, it's just not going to run. It doesn't matter how good your cameras are, it's just not going to take any pictures. So our climate system is one of the 3 planetary crises that our generation is currently facing, in addition to the loss of biological diversity, which means that we have less options when it comes to finding things that could continue to feed us, continue to provide services to us, like water as well. So there's a big loss in biological diversity and means a loss in biological options. And number 3 is pollution crisis. There's a group of scientists that's been drawing information from thousands of scientists across the world, and they've put it into what they call planetary boundaries. And you can see here, the green color parts is where we're supposedly operating in safe space for our species, not all the other species, but our species as humans to survive. And we have already exceeded quite a number of few, including the climate, including biological diversity, in which novel entities like genetic mutations and things like that come into play as well as pollution into our sources. And the estimation is that the climate change alone would cost governments 38 trillion US dollars by 2050 in damages. Okay, and governments don't want to do that. They can't afford that to happen, because imagine the amount of civil unrest, the loss of lives that could ensue. At this point in time, we have actually increased our temperature, the global temperature, by 1.3 degrees Celsius already. And the science tells us that if we are to follow what our governments have pledged to deal with the climate situation, we are only going to keep the increase in temperature to 2.3 degrees Celsius. And the way that industries and our economy is functioning at the moment, we're actually en route to getting to 4-degree Celsius increase. Now you might think like, oh my gosh, I don't know what this means, right? How does it impact our lives actually? Now, if you imagine at this point, we're already starting to see major floods and droughts happening, and lots of news saying that people are actually dying from just being too hot. There are heat waves that happen across the world. There are wildfires that have been burning down people's houses and businesses in an instant, right? That's only happening at 1 degree increase. If we were to actually reach a 4 degree Celsius increase, we're going to expect that our food in terms of rice, I think we all love rice in this part of the world. Rice will already decrease in its production yield by 12%, up to 12% by 2 degrees Celsius. And that's going to continue to increase in declines by 4 degrees Celsius. So there's going to be a shortage of our staple foods like rice, maize, wheat at that level. In fact, it might be impossible to grow if we don't even maintain the type of species of rice that can deal with such high temperatures. And remember, we said there's the triple planetary crisis of losing biodiversity. Yep, we've actually lost a lot of our species that can cope with such high temperatures. Apart from that, there's going to be declines in terms of water availability. There's going to be increases in heat waves. Can you imagine that going to work, out of the 7 days you have, there's actually 8 times that you would experience heat waves. 7 days of work, but you have 8 times you're in heat wave mode. Yeah, that's what's going to happen. Or that every time you walk out, there's actually like a 70% chance that you will be having skin and respiratory diseases because the ozone air is just too high. You could actually choke just because you're walking outside. 70% of the chance when you could go outside. So the second major thing also of why it's being driven, apart from the physical impacts directly itself, is that nations are actually getting sued. Like, remember we mentioned there was a human rights law that was a landmark case. This was actually filed by a group of 60-year-old ladies who actually sued their government for not taking sufficient action on the climate change policies they already have. So the government already did their so-called responsibility of putting out the policy, putting out the action plan. But they were actually sued for not doing enough on those action plans implementation. And this led to them having a higher chance, the elderly people having a higher chance of dying from heat waves. And it was human rights violation as such. So they actually successfully sued them, which sets a precedence for these cases to actually come into play. Once human rights realm has been breached, we've seen in the past that, human rights can actually get you into trade sanctions. It could mean expulsion from international payment systems. It could have removal of, preferential trade agreements. We've seen examples even like Malaysia's Top Glove getting their gloves during COVID pandemic times all the way to the US and then actually being barred from entry. And not only do they have to pay for all the fines that resulted, but also the goods had to, do you bring it back or do you dispose of it? Or, that's a loss as well for the company. On top of that, they had to do investigations within their company and supply chain to figure out where there were human rights violations. So this is a big step in terms of ESG as well as climate litigation. Another huge, huge thing that's happened in December was the conclusion of the hearing of all the testimonials from 94 different sort of countries, 94 countries, as well as 12 organizations at the International Court of Justice. So what is this thing? Why is it a landmark case? Now, how it started was that there was a really small country, it's a Pacific country that's considered a least developed country. They were actually moving this motion to request for an advisory opinion from this international court, which is the highest court at the international law level. Like, say, what is the obligations of countries under international law to ensure that the climate system is actually protected? Right? What is their obligation? Because when we go to COP, which is the Conference of Parties, and you have 194 countries there, the last one that happened in Baku, a lot of people said it was a failed one because there were so many nations making excuses and saying that this was not within their obligation to take these actions and solve the climate crisis this way, right? So therefore, these small, least developed Pacific Island countries actually walked out from the Conference of Parties. They literally did like their whole, I would say it's like their war chant, right? And then they walked out from it because they're saying this is a complete humiliation towards them, who have not contributed to the climate crisis. They contributed less than 1% of it. And yet they are the countries that first getting damaged. Their houses are literally sunk. They have lost their land. They have no place to live, right? And they were saying that how could they actually do that at COP? And therefore decided to take a legal proceeding to seek for advisory from this international law on the obligations that different countries have. On top of that, they wanted to know what was the legal consequence of countries actually not meeting those obligations. And it wasn't only for their states, but it was also about people and individuals in the future generations and the present generations that's already being affected by climate change. So it's really born from this frustration that negotiations are not delivering action fast enough, and therefore they've gone towards the courts. So they actually didn't use environmental laws per se. They actually went on the route of the UN Charter, the Civil and Political Rights International Covenant. They looked at economic and social cultural rights. And of course, you can't miss out climate change and the Paris Agreement, but they also looked at the law of the seas and also the Universal Declaration of Human Rights as well, with the basis that if climate change actually led to the violation of these well-established conventions and rights, therefore, when people interact with their country's governments and how different countries interact between each other, they would need to take into consideration climate change. So the advisory is expected in summer this year, and we shall see how that turns out. But the fact that the International Court even opened the case and allowed so many testimonials to actually come in, oral testimonials to actually come in at the Netherlands where they're based, is already a big step ahead. And it starts signaling to a lot of governments that they will not be able to run away from their obligations. One of these obligations that's also being heavily discussed is the obligation to deal with plastic. And this thing called the Global Plastics Treaty was initiated by a number of countries, again, who are suffering the effects of their seas and rivers being choked by plastic. Their fisheries have declined. The people are losing their livelihoods. Disease is spreading in their communities because just the sheer amount of plastic that's arriving on their shores, and the sort of insufficient financial capacity that they have to actually remove or even deal with the swaths of plastic that's arriving. So this is something that there's a major fight at the moment. Interestingly, big corporations who are users of plastic have actually lent their support for the treaty because they say we need those laws, we need those regulations across different national boundaries in order for us to make those investment decisions, in order for us to justify the investment decisions that we are telling our shareholders that we need to do. Right? So it's quite interesting at this point because with these new regulations to come into play, it might not only be the recycling waste management level. A major discussion is that plastic should be dealt with at its production level, meaning that certain chemicals should not even be allowed to exist in the first place. It should not even be allowed to be used in the manufacturing processes in the first place. And certain plastics probably should be eliminated completely. So it's taken a while, actually, if you can imagine, trying to launch this rocket into the regulatory and litigation space. For a long time, sustainability, ESG, climate is like this voluntarily nice to have. We'll deal with it if we can spare some moment or if we feel extra noble that day, right? But it's not the case now. It's actually moving a lot into the regulatory space. And there is a major need actually for more legal professions to actually get involved in this, riding this wave. as we shared just now, there's a lot of different risks that people have presented as a result of this, but it also creates a lot of opportunity. And legal risk is something that we see will play a bigger and bigger influence in molding how ESG and climate action will move ahead in the future. This has actually come in a major philanthropy impact magazine. I think they share with a lot of huge philanthropists to actually advise them that strategic litigation is one of the ways that they should be going towards in order to deliver more impact from their philanthropy work, which means that they're asking philanthropists to bring out a lot of money to pay for these litigation cases. Why? It's so that they could use it to create legal risk, set new legal precedents, or even help to develop the law. So the question I guess I would like to pose to the group of you here today is, will you be the spanner that's stuck in the gears, preventing this from happening, and eventually will be broken because the momentum that we're seeing, the pressure that governments, the pressure that we have from a physical climate system is already pressing these gears to keep going? Or will you be the lubricant oil that will make these gears move even faster and catalyze this change that we desperately need in the next 5 years? Not 100 years, not 50 years, not 30 years. According to science, we just have 5 more years to prevent locking in the worst effects, to prevent our children living in a situation whereby even if they wanted water, they might not get water. Okay? So from the association standpoint, Circular Business Association, we realize that legal risk is something that's very necessary for corporations and regulators to have their backing in order to take those actions. When those negotiators met for the Global Plastics Treaty in South Korea, Busan, a lot of them were high ambition to say we need to deal with this plastic pollution from the source, but they didn't have sufficient backing from the economy, from the legal proceedings to take those actions. And therefore, we recognize if our mandate, which is our mandate, is to solve the climate crisis and create a livable world by accelerating business transition into the circular economy that's profitable and solve it for sure, it would be that we need to smoothen all the gears that's available. And therefore, we are launching the CBASS networking for lawyers because we want to play an active role in accelerating this change using legal risk and also to help the companies that are already taking positive steps to do well and replace out the incumbent unsustainable companies. So we would like to advocate that by becoming part of this network of lawyers, not only will you meet peers who are interested to get involved in this area in the same way to deliver positive impact, move the gears much faster. I know there might be some individuals in your profession that would prefer to back companies who are incumbents, who are continuing with their unsustainable practices. But if you're not that type, we are here for you, to support you, and to actually help you move further in that direction. Also, we realize that this could have huge implications to personal safety if, let's say, you were to be involved with some of these cases. So by being part of a bigger network, not only would you be able to find lawyer sort of peers who are across different countries, but there would be safety in numbers as well if you actually pursue cases together, instead of being so identified as the one person that potentially gets a bullet through the head, right? So with that, I highly invite you to be part of our networking for lawyers. If you are interested, please reach out to us at support@circularbase.org, of which you receive this webinar invite as well. So with that, I'd like to pass the floor over to my colleague, Louis. Thank you very much, Louis, for joining us. Louis is a seasoned professional with a passion for sustainability, and he is the group chairman for ACMF Group of Companies, which provides ESG consultancy, international private capital raising, and sell-side merger and acquisition services with a footprint of over 10 countries. Louis co-founded ACMF with over 10 impact-driven co-founders and shareholders from corporate backgrounds like venture capital, investment banks, capital market regulation, private equity, and national climate policy. One thing people don't know about him is that he retired in 2012, but due to his passion for solving the climate crisis, he started Climate Movement 2.0 and came back to business world in 2015 when his friends called him crazy, but now they call him visionary. Lewis, you have the floor.
Thank you, Regine. Allow me to share screen. Thanks, Regine, for the excellent sharing about climate impact and potential trends. And yeah, happy afternoon, everyone. My name is Louis. I'm from ACM IPF International Fundraising. So our teams are primarily from private and public capital markets background. We mainly focus on profitability and business part of the ESG and climate crisis. And according to many people, probably we are the people have to learn to eat and drink money when climate crisis destroy our food system. So I very much focus on the business side and monetization side of it. We believe that very important to change anything, especially now the world system that heavily depend on GDP and all that. I would like to share some number. According to survey, over 75% of consumers would stop buying from companies that degrade ESG. And over 85% of consumers want to engage with companies that are more committed to ESG. And over 9% of consumers would pay higher price for products that are more ESG. And also research last year found that SME that implementing ESG practices has had this 20% increase in revenue. But when it comes to ESG investing market size, it has grown quite a lot. It's predicted to grow over 167 trillion US dollar by 2034 in 10 years time. And according last September survey on institutional investment firm like those public equity, hedge fund, private equity, venture capital, and over 90% of them already adopted or incorporated ESG factor in their investment mandates. And December last year, for the first time, suing companies and government for ESG violation have become investable investment. And our fundraising teams have spoken to institutional investors from about investing in ESG litigation financing. Over 70% of them, institution fund, are willing to expand to ESG litigation financing because traditionally this kind of financing is very profitable for them because the investment models are more accurate as compared to their seed and venture investment models. Um, just to share a high-level process of working with ACMF on litigation financing. First step is to email us esg@acmfgroup.com about your case. We do not want to know the names of the parties involved during phase one. But we need to know the geography of the parties, and because the case could involve a local against overseas multinational companies and all that, and we also need to know the nature of the ESG violation. Like, is it about greenwashing, about pollution, board violation, or any others? And during the phase two, is that after the team we have done a preliminary matching, we found that there is a mandate, investment mandate in your case. Then the phase two is that we will have a private Zoom call with you. We only want to talk to the legal firm during the phase two, because when we do the after we receive the email, we have over 10 fund arrangement teams globally. These are the people talking to investors in Asia, Europe, Middle East, North America, and they have like weekly, monthly meeting about the latest investment mandate. At this point in time, we do not want to talk to the plaintiff. We just want to ensure ACMF we fully understand the case before talking to the qualified investor. And we need to know the total investment needed for your case and the tranches of payment, means how much investors need to inject in your case in year one, year two, year three, and so forth. And also the potential timeline of receiving award and money in this bank, for example. The phase three will be the one that many ACMF, our internal process, the sponsoring fund arrangement teams, they need to reach out to their qualified investor. Qualified means there's no conflict of interest. That means they losing the case or winning the case to some extent. Like for example, they might involve in the competing position versus the plaintiff side. So and also align with their investment mandate. Like for example, like the investment ticket size, what's the duration they can wait. Some they can wait for 3 years, some they can wait for 15 years. So and also the potential return. Some they okay with a lower return, but they want a very secure position. That means they want a lot more data points. And some they're willing to take risks as long as aligned with certain agenda. They're willing to invest, but that they will ask for very high uh, return. So
Okay, right. In that case, thank you very much for attending our webinar on ESG and climate litigation, the next gold mine for your legal practice. I really look forward to seeing you all at a networking session for lawyers under the CBASS self-initiative. And thank you again for your time. Until next time, we'll see you. Goodbye.